Okay, I'm going to go ahead and call the meeting to order. And John, since I'm here present, I hope you don't mind me chairing the meeting.
No, absolutely.
Hopefully we'll have a much shorter meeting than what we're used to. And the first thing on our agenda, of course, is just if there's anyone in the public that wants to make a comment on any non-agenda items. I don't know if we have anyone from the public that wants to do that. But hearing none, we can always come back to that if someone would like to do that. So why we're here, of course, is agenda item number 3, which is a recommendation from a working group known as the Unauthorized Practice of Law Working Group. And in the memo that I sent to everyone there through Abby, you'll see that this working group has been diligently working on a rule that deals with the unauthorized practice of law with regard to real estate brokers and agents. Essentially, you're probably familiar with it as to what an agent or broker may or may not do with regard to various forms and what kind of forms they can use. So they are making significant recommendation to the commission to consider for changes to that rule. So I serve on that committee. Brian Watts also serves on that committee, and Diane McCoy also serves on that committee, who are all members of the Broker Lawyer Committee as well. And one of the items that came up was special provisions and the definition of the factual statement and business detail. I think something that the industry. So this working group.
Ron, maybe the rest of us need to all make sure and mute because somebody's typewriter or something just knocked out everything you said.
I'll add that in, yeah. So if you're not speaking, if you can mute, that's always helpful. And if you are a committee member, we'll need you to have your camera on for open meetings purposes. I see a lot of you.
Good. So the committee got deep into this whole issue of factual statements and business detail and special provisions. And their final recommendation was to change the terminology and get away from factual statement and business detail and suggest informational items is probably more akin to what we really mean when we're talking about what goes into paragraph 11 or special provisions. And so they came up with a suggested definition of an informational item that's in the memo that I gave you that says it's a statement that completes a blank in a contract form, discloses factual information, or provides instructions. They talked about the various things that normally come up with regard to what goes into special provisions, what's appropriate, what's inappropriate for special provisions. And so they then are suggesting to the commission that where they see factual statements and business details in the existing rule, that be changed to informational items and with this definition. And then along those lines, at their last meeting just a week or two ago, that working group then came up with the suggestion to the Broker Lawyer Committee to change how paragraph 11 appears in the contract forms, which is there in the memo for you. And the title that would change to informational items with that language that you see right there regarding the unauthorized practice of law. So that's really the whole purpose of this meeting. And given the timing of the fact that the Broker Lawyer Committee has already sent its drafts to the commission, and the commission will consider those, we call this special meeting because the committee thought and the staff thought that if we're going to make this change, it's probably best to put it into the forms that are actually published out there for the industry and the public to see with this change in there, because it might raise some eyebrows. I'll also let you know that Lori Levy with TR was on that committee, or is on that committee, as well as Rick Albers and Jan Fike Miller are the other members. Did I miss anybody? Okay. And then, of course, our well-informed and knowledgeable staff is guiding us along the way as well. So I'm going to leave it open for comment right now that we've laid that out, to see what you think, and then open it up to anyone from the public that'd like to make comments after we have a moment to discuss.
I'll jump in. This John George. I like the change. Part of me has that special connection to special provisions that's just hard to swallow getting rid of. But in diving into the core of it, this is one of the problems in the contract, recurring problems with agents in the contracts writing things in. And I agree with the working group that this definition they created much more aligns with the intent of how that is to be used. And so besides some non-rational holding on to old terms, I do like the change and applaud your efforts in doing that.
SJ, do you have your hand up?
I do. I think Brian beat me to it, but I'll jump in. I have a lot of comments. I would second the one that John just said about the affinity for special provisions, that name, that title. And frankly, I think informational items is just way too weak. That title, the definition I'll talk about in a second, but the title alone, I think it's too weak and it's frankly misleading. We do allow in a limited scope, i.e. anything that's not in the promulgated form already not addressed in the promulgated form, deal points can be added in. And I think we ought to give some examples of those. One I thought of in the shower was this offer expires on, October 7th at 5 p.m. or something like that. But I'm just very concerned about this informational items because they're not just for information. They're actually material parts of the deal, or they wouldn't be put in the contract, generally speaking, or at least some of them would be. I mean, maybe one of them, maybe something is informational, like you need to call first because there's a dog in the house, but I don't like that title. I think the definition is going to cure a lot of things, but I do think it's just too weak to convey what we really want it to say. Somewhere in this new language or definition, I want it to specifically say that license holders are not allowed to strike, change, or add to the actual promulgated contract language. You're telling them what they can do, but I think we have to tell them what they can't do.
SJ, if I can stop you there, only because I know that's a natural tendency to go into the work of the other working group. That rule does address those in other parts. And so the purpose of our meeting is either to accept or not accept this change for paragraph 11. But we can listen to those comments about the other part, but you're correct. Those issues are addressed in what they can add or strike in other parts of the rule.
Well, they're addressed in the rule, but they're not addressed in the contract. And that's what
Okay.
My concern is that in the contract, it ought to be clear, not only for the agent who ought to know better, but for their client also. This will help the agent steer the client to an attorney when it's needed for more serious drafting. But thank you for reminding me, probably everybody, this is not a committee, this is not a member of the BLC committee's draft. This is another committee's draft, and thank you. I will note that too in my comments. But overall, that's where I am on this. This is just, I don't think it goes far enough. I could probably get over the informational items if the definition was more robust, including examples and what is not allowed. And I'll stop for now.
Brian, did you want to chime in?
Yeah. What SJ's just been talking about is something that has been bugging me, I'd say for the last 30 years. And that is, where do you draw the line as to what an agent can put in and what they can't put in? And SJ said, well, what about, just a little simple clause, you may not need a lawyer, but the parties agree that, this offer is good for 5 days or something like that. Well, the problem is that I think you have to have a bright line test for real estate agents, or else they're going to continue doing what they've been doing before. And we have to have something that says, this is the contract, these are the terms, and real estate license holders are not to go off the reservation and draft whatever they want to draft, and we got to have a bright line test. That's comment number one, and that's why I like being clear as to what informational items are, and I think that is very consistent with what TREC educational materials have been saying for the past many years, but it just really hasn't been as clear, and this is making it clear. One thing that I think could be made a little bit clearer in this paragraph 11, in the, for example, drafting language in this contract or recommending language not drafted by an attorney for this contract. Well, what's going to happen is agents are going to read that and they're going to say, well, I can't draft it, but I can call an attorney and they'll draft it for me. And so they're going to call John George up and say, John, I got this deal here for your title company, and I need a clause that says such and such. Could you help me? I'm not an attorney, but you are, and you could draft it for me. And so I could see us being a little tighter in this language, not drafted by an attorney for the seller or buyer for this contract.
That's a good comment.
And I don't know if that's too broad or not. Are there other situations? But I don't think that precludes use of a Texas Realtor addendum that's otherwise authorized. But if you're putting something in paragraph 11, it has to be given, and it's more than an informational item. It has to be something drafted by the attorney for the seller or the buyer, not an attorney for the agent or helping out the agent.
Thank you, Brian. And for just y'all's information as well, the committee talked about, the working group talked about exactly that point. And they also clarified that a broker or agent can reimburse a client for attorney expenses. Nothing prohibits that. So they focused on the issue of making sure everyone knows who that attorney represents when drafting that those clauses.
Yeah, and if I could give an example too, any of the attorneys here that have done insurance defense work know that an attorney can be reimbursed, his attorney's fees can be paid by the insurance company, but who is their client? Their client is the individual they're representing. Okay, so you can have a third party pay the attorney's fees, but you have to create the attorney-client relationship between the attorney and the person actually benefited by the advice being given.
Lee, did you have a comment?
Yeah, I quite frankly, I'm not sold on this either, but I want to make sure that I know where we're at in the process. Today, if broker lawyer committee agrees, then my understanding is what happens is it goes to the commission, if they agree, then it goes out for public comment. It's not a done deal, right? It goes out for public comment. And then when that period is up, BLC has the opportunity to review it, compare it to public comment, and possibly make some tweaks. Is that right?
Yes, I'm going to rephrase it slightly.
Okay, that's fine.
What we're doing today is actually changing our draft that goes to the commission. If this goes in, okay, then the commission receives that and they decide whether to publish the entire form or not publish the entire form. Assuming they receive this change as our draft and they decide to publish it, then you're absolutely right. Everyone will see it and have a chance to comment on it before final adoption, which is why the Unauthorized Practice of Law Committee wanted to suggest making this change now because of that exact question that you're posing.
Okay. Yeah, so I have a great deal of respect for the people who are on that committee, which is what gives me pause, because I'm not really on board with this. At the same time, I know exactly which sword I'll fall on in my BLC career, and this is not it. So.
Tony.
Thank you. Yeah, Lee asked a question that was kind of my knowledge. So basically, it's we either like it or we don't, and the ability to change much of it, we don't really have right now. Because I was kind of with the SJ, and I'm sorry.
You can change what's in front of you because this is just a suggestion to the Broker Lawyer Committee to change paragraph 11, which is within the purview of this committee. So what's before you is a suggested draft of a new paragraph 11 language, and we do have the right to change that. We can change that.
So if I envision this right, I'm a visual guy, there'll still be paragraph 11, it'll still be that section, but they now want to rename it this kind of vague title of informational information.
Right. So Brian has already made a recommendation that we add for seller or buyer right at the end there.
Yeah, I liked a lot of Brian's comments, and I think Brian's right. A lot of people are still going to do what they want to do, but he was talking about verbiage that really never delineates when are they too far or when are they not. And I think he kind of said it without realizing he said it. I mean, you could put in there, you cannot add, delete, or modify any of the terms of this contract, but I'm not sure what will work. So, but I like that you cannot add, delete, or modify any of the terms of this contract. And I like that definition better for whatever informational, how we define informational, even though I don't really like that topic. So I guess I'm on board with some change, but I don't really like this. And so I don't know if we're supposed to open this particular meeting up to really redrafting all of it.
Well, you can redraft if you like. We can either say, yes, go with this suggestion, no, do not, or come up with an alternative suggestion and send that to the commission. Those are our three choices.
I don't have a fabulous title name. I wish I had something really catchy or really simple or the plug in there that was better than what we got. But as a definition, I would delineate you cannot add, delete, or modify any of the terms of this contract. Because that seems to be, whether they catch on or not, that does seem to be what most of the agents do. They either, and you might even put add, delete, modify, or put a contingency in for this contract, because they seem to add a lot of if, ands, ors, but if this happens, but if that happens, or that seems to be the problem. And I think John and the title company fellows may confirm that.
So we would probably need to work on that language if we want to go that route and do that, because obviously we can add contingencies via addendums, either from that our attorney drafted or Trekker drafted or association drafted. So
Well,
we'll have to work on that.
I over-lawyered. When I added the word contingency, I'll admit I over-lawyered. I think it's just cleaner if we just say you cannot add, delete, or modify any term of this contract.
I think we're gonna need to, let's take that comment for now, and if we want to modify the language,
Okay.
we'll get into the week of that in a minute. Greg, did you have your hand up?
Yes, it did. Back to SJ's comment about informational. I find that could be just like the example was used, well, put the dog up after the showing. I'm afraid as a licensee, we may just use that as things that are not really contractual. Business fact, I don't want inspections done prior to noon. But my main point here is in the amendment itself, number 9, we use the term other modifications. So I think we're really talking about, aren't we, kind of the special provisions of an amendment, and we're talking about the special provisions of the contract, and whatever we arrive at, do we need to have those terms the same?
Good question. We talked about that in the Unauthorized Practice Law Committee. The purpose of the amendment is to modify the terms. So that would be an appropriate term to use in the amendment form. And so that would be, now the whole question there becomes, are you drafting something in a blank line that requires the use of an attorney? So then the whole question came up is, do we just simply delete other modifications from the amendment? But the committee's not made that recommendation, at least not yet. But it is proper for that amendment form because that's the purpose of that form.
Okay.
Let's see, any other comments from the committee members? And then I can open it up to the.
Yeah, I got something else. I want to reiterate what Greg said. The contract is the place where you put your agreements and not your discussions. What I always tell agents are contracts are from Mars, discussions are from Venus. If you want to just talk about how you feel or what you'd like to have, that doesn't belong in the contract. The contract is what we say we are going to do, and it should be boom, 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 and not have outside discussion. So I agree with Greg there. Listening to Tony and SJ, I like what they said. And so instead of that parenthetical, for example, why don't we just say something like, do not add, delete, or change any provision of this contract unless drafted by an attorney for the seller or buyer in this contract, period.
I'd like both. I'm sorry to jump in, but I like what I said and Tony said better. I like his language better. But I want it in addition to what's already there with the addition by, I guess, Brian, that the attorney is for buyer or for seller or buyer. I want it all in there.
Well, and a comment on that is we have to be careful because the consumer can insert any clause they want without their attorney. So as we're analyzing this language, and I fully agree with adding something about for agents direction on having the buyer seller's attorney draft the language. But I think we need to keep in mind the buyer or seller absolutely can write their own language in here. So I don't think we want to steer them completely away from that. And in that same vein, I just for kind of to make sure we're on the same page, that 537.11 provides that an agent can employ or pay for the services of a lawyer directly or indirectly. And this has been one of the biggest sources of contention in my practice, having agents request language to be drafted and trying to find ways around that rule. And so the comment was made earlier that the agent can merely can reimburse a client for their lawyer fees. And I'm not sure that's accurate from my reading of the statute being directly or indirectly. It seems to me reimbursement would be an indirect payment for it. So as we're looking at this language, I would just like to add that comment to the extent that it impacts it.
Just as a heads up, the committee is modifying that language on directly or indirectly engaging an attorney as well. And they're more focused on, for the purposes of clarifying who the attorney represents, so reimbursing or paying for the services of an attorney. So they are focused on that part as well. I think Mary had a comment.
Yeah, my comment is, I mean, informational item. I don't know if I like that title, but the biggest thing here is what people are doing are putting stuff as contingent to a contract that should be in 7D. 7D2, I will buy this house if you do A, B, C, and D. And they always put it in special provisions instead of putting it in the right place. And I don't know how we, I know it's through education, but I don't know how else we get that done. The other thing is maybe put in parentheses, like we've been having a lot of escalation clauses. No escalation clauses, because our out-of-town buyers are asking for them to be put in.
Any other committee members? I think what I'm going to do is open this up for some public comment right now, and then obviously we can continue. And then I'm going to ask Abby to share her screen, and maybe we can get into some drafting alternatives and look at what we can add to this, and if we want to do that. So I know that Mickey Mickey Lackey is here present, and she'd like to make a comment. So if you'll step forward, so
yeah, can I get where, can everybody on the screen see me?
they can hear you well.
Okay.
Be able to see, yeah, they can see you.
Okay. I want to first thank you, and then I want to secondly apologize. I spoke in front of the commission back in May last year because I had some problems with this. And asked this to be looked into. It became very appropriate this year, since this year is the required quadrennial review of 53711. 4 years ago, it was reviewed as well. 4 years ago, the seller didn't, or the buyer did not have to give written instructions to their agent about what they wanted in the contract. And the quadrennial review 4 years ago did require the client, who what is the man's name in the red shirt?
John.
Thank you, John. Because you touched on what I feel is the crux of this matter. And I don't think we should get bogged down in dictating language until we truly understand the problem. Also, in the quadrennial review 4 years ago, we removed some critical language from 53711. It used to say, paraphrasing some of this, that the client could direct their agent to modify the contract to, or to add to the contract, to modify the document to the intent of the principals. And yeah, that was explanatory. But once you look at that explanatory language, you might start to understand that this is not our contract. It is their contract. It is between the buyer and the seller. And thank you, John, for pointing out that the buyer and seller can pull the contracts up from the Trek website and use them, or they can write their own contract on the back of a napkin. They can write an escalation clause. They can write a contingency. They can draft language because it's their contract. The problem with our rule, and it's often misinterpretation, is that it says agents cannot draft a contingency, an escalation, draft any language that affects the rights of the consumers. But the consumers can. Just as in my original report, has anybody actually seen that 19-page document that I submitted?
Yeah, we did.
Okay, just like I said in there, agents cannot sign their client's name. That doesn't mean that the client can't sign the client's name. As soon as the agents understand the liability that they're taking on by drafting language, I think that's going to curtail a lot of it. And I think if we understood what the law says, and remembering that the rule for agents that we're reviewing, 53711, is part of the TREC rules, which govern licensees, doesn't govern sellers, doesn't govern buyers. And there's an overwhelming attitude that we need to keep these people from writing stupid things. They're going to write stupid things. It's not within our responsibilities and duties as real estate practitioners to make a legal judgment call about what they can write and what they can't. But maybe when the clients understood that if this language can be misinterpreted, it will be misinterpreted against you by lawyers. So you can write what you want as long as you give me written instruction. And this rule already says this. The clients can give the agents written instructions as to how to modify the contract. Striking out, let me give you a bad example, just the first one that comes to my mind. A lot of builders will strike the rollback taxes. And if the builder doesn't want to pay the rollback taxes, even though the boilerplate of the contract says so, and the purchaser agrees, who are we to say they can't strike that out? It's their contract, and yes, they can. If you look back at the statutes, if you look back at how the public who can write these contracts themselves are regulated, they can certainly do it. Now, I 100% agree that they say stupid things. It's not our job to make sure that they don't. We can maybe ask them questions to clarify. We can maybe say, if this language goes to court and it can be misconstrued, it's going to be misconstrued against you. So it's a really good idea for you to check with your lawyer, to ask your lawyer to write it for you. But if you write it down, it's on you, not me. Mr. Seller, you want this in the contract? You write it down, you sign it, then it's on you if it comes back to you in a court of law. And you know, if nothing bad ever happens, nothing bad ever happens.
Ms.
But-
I'm sorry to interrupt you. I have to keep you on point here. I
Okay.
apologize for having to do this.
Okay.
So a lot of what you're saying actually needs to go over to the Unauthorized Practice of Law Committee. The issue, the agenda item that's here
Uh-huh.
before us is a recommendation of certain language to change paragraph 11. And I know these issues are a little bit mushy together, so I want to give you enough room to make your comment. But what we're really looking for is any comment that you have with regard to the issue of changing the language in paragraph 11 that says no longer calling it special provisions, but calling it informational items, and then any admonitions that might go in the parenthetical that's there currently.
Okay.
That's what this agenda item is.
I can speak just specifically
Okay.
to that point.
Okay.
Since the general public can, the buyer or the seller can pull these contracts off of the website and use them themselves, putting rules that they don't have to follow into the contract that they're trying to write is, I don't think effective. And this needs to be rules for agents, not rules for buyers and sellers. And if I misunderstood the purpose of the meeting, I do apologize.
No, so I'll ask you, the item before us is the language changing special provisions to informational items. Do you have any comment or concern about that?
I know that factual statements and business details has been used as a red herring, as a straw man, as you will. I was told it doesn't matter. I was told that that paragraph is reserved for factual statements and business details. Well, duh. We want it to be true. We want it to be about the transaction. But what we need to say is agents can't draft it, clients can. We need to not penalize agents for writing what their clients instruct them to do. And the delineation is there. And I think the terminology gets lost in,
Right.
Let's focus on what the meaning of factual statement is, what the meaning of business details is, because it's a big duh. So what? We need to be not quite so specifically vague, if that makes any sense.
Right.
And I'll yield.
Okay,
On
thank
that.
you. Thank you for that comment. I appreciate it. Are there any other public persons on, or should I say, members of, no other members of the public online that want to make a comment? Okay, I'm going to ask Abby to share her screen and pull up the draft that's before us, and then we can make some suggestions on modifying it. see what we think.
Well, I can't see that. I think that's what's over here.
So let's see, Brian and Tony both made, and SJ, each of you made specific comments. Let's get Brian's in there and then Tony's in there and SJ's. Brian, so you want to put.
Okay, well, first of all, the second sentence, do we now not just use the term license holders rather than real estate brokers and sales agents?
We do in the rules, but in the contract, we refer them to as
Okay.
real estate brokers and sales agents.
Okay. Okay, so what I would suggest, let's have that second sentence where it says real estate brokers and sales agents are prohibited from practicing law. And then let's insert this, delete the parenthetical and add the following. And may not add to,
Shall.
delete, and shall not add to, delete, or change any
Modify.
provision of this contract unless, and then strike everything until drafted by, unless drafted by the seller or buyer or an attorney for the seller or buyer. Period.
Okay, Tony, did you want to have any changes to that?
Yes, I think Brian did a great job. I was actually going to go with license holder, but I understand why we're doing it the other way. I think a lot of our terminology in our forms use the word modify. While change is a nice layperson term, I would do shall not add to, delete, or modify any provision just to keep the flow good. I mean, I get change is a good layman's term, but I think we use the word modifications in a lot of our contracts. Unless drafted by the seller or buyer or an attorney for the seller or buyer. I think that's
or
pretty
by
good.
an attorney. I think you have to put after the or,
Oh,
or
yeah.
by it.
I don't know if you like just using or their attorney. It's up to you if you want to.
Well,
shorten
then who's there?
it. Okay, I'm fine with
Modified.
it.
Does it modify seller, buyer, broker, or sales agent?
You're fine. Just go ahead and leave it the way it was, or whatever he suggested.
It's more
Should
logical
seller-
English to say seller or buyer's attorney, seller's attorney or buyer's attorney. Instead of, or buy an attorney for the seller
Okay.
or buyer.
That's
I'm
good.
speaking
Shorter.
regular English.
SJ, you had some suggestions here.
Well, I'm noodling on them a little bit with this change. I think I like it the way Brian and Tony have got it. I think,
Oh.
but what, okay, so our whole point of this informational items is to, this is the instructions that essentially say, you're filling in a blank, that's an informational item. You're disclosing factual information. I don't know what that means. I mean, I know what it means, but I don't know what it means here, or provides instruction. I think the fills in a blank is kind of confusing to a user because there's a lot of blanks in this contract. Do you mean this blank, the blank for informational items that used to be special provisions, filling in that blank? Or are we just defining informational items as everything that gets filled in, all the blanks that get filled in the promulgated form?
It is, I will tell you that the committee looks at it as all blanks in the form. So like when you put in the number of days for the option period, that's an informational item that you're adding to an existing provision. And
Okay, well
so
then, oh,
the question
sorry.
came, since special provisions is blank, then
Yeah.
we had to be a little more clear with regard to
Right.
special provisions.
Well, I think it's real confusing though, when in the body of now 11 informational items says this paragraph is intended to be used for informational items only. So you're giving mixed messages saying, okay, fill in all the informational items in the whole contract, but this paragraph is to be used for informational items only. That to me as certainly as a layperson or an inexperienced agent might mean, oh, well, okay, I can only use this paragraph. You mean it's for informational items only, but there's other informational items that are the only things that can be filled in elsewhere. Somebody else can make that language better, but I hope I'm identifying the confusion that I believe this is causing.
Yeah, it's a tough, it's not as black and white as we would like, not the clear line as much as we'd like. It's a little bit mushy, and this was a struggle where you're suggesting, right? You're hitting on the point that's the hardest point for us to make in terms of defining these terms. John, I think you had a.
Yeah, and I'm just going back to my love of special provisions. So I'm throwing this out there. What if we kept the title special provisions and then change up the definition? And to SJ's concern or point for informational items, what if we added the word additional before it to then leave open that everything else is informational as well that's being added? And so just with that one addition, then it leaves open our consistency with all the other blanks being informational in nature.
So you're suggesting specifically what change here?
So adding additional before informational items, so it would read, this paragraph is intended to be used for additional informational items only. And I do like the other, I don't know if I like all the ors that are at the end, but I do like the language that is there.
Did we pull in the definition of informational item that the working group is considering?
There you go.
What is an informational item?
I should have just interrupted with that too, Brian. That's what I was gonna say. It's in the rule, but it's not in the document, and it should be in the document. I would put it, if we're gonna leave these sentences in the order they are, I would have it be the second sentence. So this paragraph is intended to be used for additional information items only, and then define the informational item is a statement that completes a blank in a contract form, discloses factual information, or provides instructions. I still would like some examples. And then you roll into the real estate brokers and sales agents are prohibited from practicing the law.
But John also suggested leaving the title back at special provisions.
Yes, I like that too.
And
I
like the idea
team
of leaving it
special
with special provisions. I'm on team special provisions too.
Yeah. It looks like there's an extra space after the word delete, but I would like to just look at this for a second, but I think.
Can I add one small thing? I believe seller buyer is a term that's supposed to be capitalized.
Yep. Catch. Can we consider having some examples after this definition of informational item?
Can I speak to the examples idea?
Well, the one that Brian didn't like that I said, that I think fits in here is this offer expires at date and time.
Yeah, I mean, to me, that doesn't even make sense because they can't, it's not a thing until they've agreed, and then it's pointless. So I don't think that's a good example.
Yeah.
But my problem with examples is I think that license holders and consumers alike see examples as suggestions.
Mhm.
And so I'm not a fan of having examples in there. So that was my main thing. Another thing is at the end where we use seller buyer or seller buyer's attorney, I'm really fine with that. It's not a big thing. But what if we said, or a principal's attorney or a principal, instead of having buyer, seller, just because paragraph 1 identifies them as the principals. So, I mean, that's a thought. And then lastly, instead of having a big blank space, maybe we put in some lines.
Well, it's actually the parties. They wouldn't be the principals. It's the
Okay,
parties.
that's fine. Parties. I'm fine with that. Parties. Just a way to,
Mhm.
y'all know I just always like fewer words.
I would agree with Lee's comments, even her criticism of my example, and I withdraw that example.
Thank you, SJ. I appreciate that.
Can we say a party to this contract?
You're adding words that are not necessary. And party, yeah, no, it's
Party's
not.
not a defined term.
That's,
Contract.
well,
Well,
actually it is in paragraph 1, but it's not a capitalized term.
Right.
And on the first sentence, I love that word only, and I'd like it to be earlier in the sentence. It is intended to be used only for additional informational items.
Good with that. Would it be possible, I'm trying, okay, I understand about the suggestions. Maybe if it's back in the rule, that might address concerns about the potential discipline for violation. If back in the rule, there was some examples. They're not sitting here in the contract as a checklist for agents to add in, but maybe for guidance for people trying to figure out if they're about to get
Well,
in
the
trouble
big
or not.
problem with educating in the contract, it tends to lengthen the contract too much. I mean, you can always reference a rule and then that can have it. But I think when you start educating, you really lengthen the contract form itself. So we have to be somewhat jealous with that.
Right. No,
Well-
I'm not suggesting that. I'm just saying as a message back to the working group, the UPL working group, perhaps in the rule, as you're modifying, maybe you might provide some examples.
Thank you.
And on the education point too, the last legal update materials had, I think, 20 examples of this exact issue that went through. And I tell you, agents struggled with them. There wasn't a single good business detail in any of those questions. So it's been part of our educational materials for a while, and it's still a struggle, which highlights the difficulty of adding any particular examples, I think, in a concise way in this contract. So I do think that would be difficult and would be in favor of doing that.
Well, then why do we have it? I'm kind of back to Scott Kessler's first comment. If there is nothing appropriate that can go in this section, why do we have this section?
Well, there is an appropriate, there are things that are appropriate for it. It's just agents have a hard time doing it. So I think this change is moving towards the direction of helping steer the agents away from adding that. And this language is a step in that right direction, with ultimately tied in with education being the best of the worst solutions we have.
If I may just piggyback onto what John's saying, sitting on both committees, I wanted to sit back and to listen to the experts on broker lawyer committee as they massage what we spent a lot of time on with attorneys for staff as well. And I think your end result is just what the intent was. of the committee working on 537.11, this item in special provisions, section 11, the contract just kind of naturally came to be. And the timing of it, we wanted to have it move forward to you, and thank you for having a special meeting. But I think what you've accomplished, the intent was to try to get the license holder to be much more reluctant in putting anything in there and having it in the contract for the buyer and the seller, the parties, to realize, don't ask your agent or expect your agent to draft anything here. Go to your attorney. And I think you did a fabulous job on putting the right words together in what the intent was of the committee, in my opinion.
And if I can add to that, this is Scott. I totally agree. I think I didn't like special provisions because everybody had a factual statement, business detail that they did not think was appropriate to put there. I think this defines it. I like the change. I think it'll be a good change.
So I'm hearing a rather good consensus here that we like this change and would recommend that we send this change up to the commission as part of, in other words, asking staff to modify our drafts and then take those to the commission at their meeting. There was, Abby had a question here for us about the amendment form, so.
Yeah, so, and I'll share my screen just in a second, but the amendment, so as Greg pointed out, it does have an other modification section, but there is a parenthetical that follows that says insert only business details and factual statements, I believe. So I don't know if because we are sort of cleansing the forms of those terms, at least the contracts, if we want to also look at the amendment language as well while we're here.
Is that form up?
It is up, yes. So it will be proposed if the commission decides to do so at the August meeting.
Okay.
Abby, if I can say something to that real quick, I've got a hard 9. I like the other modifications because if you have a contract and you have to take a purchaser off, or legal description was wrong, or a name was misspelled, that's where you change it. You reference the paragraph and then you change that paragraph. So I don't know how much tweaking we can do on other modifications. I think it's pretty well defined the way it is. And that's just from a broker's point of view that uses it quite often, cleaning stuff up that might be wrong on the original contract.
Okay. You could have, usually what you see, if there's some other clause that's not listed in these 8 items above, such as some addenda that's rarely used, like the loan assumption addendum or seller financing addendum, you can make the change here that needs to be made, and that works. Or even in the lease forms, that can happen as well. So actually, I don't know if that instruction is actually even accurate, because we might
why don't we just say insert only informational items?
I have another suggestion.
Being not.
What if we take out the parenthetical and put in the very last sentence that we just added on special provisions, where it says that license holders can't practice law?
Yeah.
I mean, that's a pretty good warning, and it allows them to do everything else.
And this is, again, another form that can be used by the consumer. And so they're not limited to factual statements or business details here. And
Yeah.
You know, we're looking at this from the agent's perspective. So I fully agree with that comment of not too narrowly looking at this, but getting across our concern about the agents practicing law in that particular section.
So just adding a statement that the brokers and agents may not practice law is sufficient, as opposed to that parenthetical is what you're suggesting, John?
Yeah, to follow up on the other suggestion of, I'm not sure the exact language, but having that concept come out in the parenthetical, because I don't, personally, the current parenthetical to me doesn't allow this form to be used by the consumer in a way that they can use it.
Right.
Hey, can I go back to paragraph 11 and make a suggestion?
Yeah, we're
The last sentence. Could we, after the word unless, say unless it is an informational item or is drafted? Because they can add informational items. Or is.
I think that's a bad place to put it. I like your comment, but we're in.
Except for informational items?
They can't, no, that's
Real
just the
estate
wrong place
brokers?
to put it in that, because you can't add, delete, or modify any provision of the contract at all, period, the end. Okay, any provision of the promulgated contract is not up for change.
I'm adding to the provisions of the contract by adding an informational item.
That's what it says
That's
above. That's what it says above,
Mhm.
is it's intended to be used for additional informational items. I understand what you're trying to do, but I do think whoever said it, you're over lawyering this. That's too much. No sentences should be running on.
I think it was John
3.
George saying I'm over lawyering.
Well, I'm telling you.
I think that was Tony. I want to give credit where credit's due.
Lawyers,
Dang it.
that's over lawyering.
That George. All right. Okay.
All right. So real quickly, back down to other modifications below, we're going to say insert only. Oh, you're going to say.
You're going to take that out.
Practice law, I think is what you're going to say.
Replacing, right, that whole parenthetical.
Right.
And not even having the parenthetical itself. What is the parentheses?
Well, I mean, right now it's just it's a comment. That's the reason why it's a
I see,
parenthetical.
that's in the parenthetical. Okay, fine.
Right now, if you look at paragraph 11, that whole language is currently in a parenthetical since it's a comment. So we can either leave it like this with or in a parenthetical. It doesn't matter to me. It's one way or the other. It's preference.
That's
If you
right.
if you took a look at paragraph 11 currently.
The whole entire statement is parenthetical, and then it's just the big blank. Smaller than it used to be, but still a big blank.
So Lee had made a suggestion about lines. I wanted to bring that one back up to you as well to see if you prefer lines to the blank.
How do the software systems that agents use work with lines? They are lines when they go to fill them in. I don't know that helps anything.
I was just thinking consistency. There's nowhere else in any other contract where we just have a big blank space. There are places where we have, 2 or 3 lines that they can fill some things in. So that, and I mean, obviously a blank space or lines is not that big a deal to me. I just thought it might help limit what gets put in there.
Okay, it's not a bad idea. I like it personally.
Ron, can you put those parentheticals
Look
in?
how smart I am then.
Yeah, thank you. Before we forget.
I like the lines.
I think that's 100% broker decision.
We'll do it in the amendment form as well.
It'll draw their attention, that's for sure, because it's something new.
Well,
Okay, let me ask this though. On the amendment, if you do that, there's no lines up on 2 about repairs and
True.
treatment. So we
True.
need to be consistent.
Okay.
So I would either not do it, or you're gonna have to add lines on 2. Again, I don't care. I think that's up to the brokers.
it actually makes it, I think, more consistent with the rule, because then you know that.
We can do the lines, it's fine, but most of us are using a computer program which has a limited number of spaces anyway, so lines or no lines, it's gonna be similar.
Right.
Well, right, but don't forget about the public.
I understand, I understand.
And these forms are fillable off track anyway for people. I'm going to go ahead and protest again. Lawyers who are not also brokers who can't access.
Yeah, but if they're fillable, you're saying fillable, you don't mean like they can type it in there.
Yeah, I do.
Okay, then that means the same thing. There's spaces available. So whether you have lines there or not, there's limited spaces for characters.
Let me, hey, Charlie,
Yeah,
I'm about to teach you a hack. You can
yeah,
put as much as you want in there, just change the font size.
yeah,
Yeah, I mean, it doesn't really limit it.
yeah.
Yeah, if you go on the website, Charlie, I mean, you could just start typing, and it doesn't show up as lines. I'm doing it right now. It's just a
My
big thing.
favorite, see attached Exhibit A.
Oh, God help us.
Oh, you beat me to it.
Some things will never change.
Okay, good.
So are we doing no lines or lines?
Lines,
Okay, and you're adding lines to
2.
2 of the addenda
Right.
amendment, sorry. And that's not material staff, right? So we don't, it could just happen.
Well, they haven't
We
been
haven't
published
proposed,
yet.
yeah, we haven't proposed them yet.
Okay, so I think by changing informational items and keeping special provisions, you guys have done a good work here and kept hell from freezing over when it goes out for comment, I think, for the most part, among the industry.
Hey,
So
do we have to put the same language in the seller and buyer temporary residential leases?
So we don't have currently in both of those forms, it just says special provisions. It doesn't have any of that additional parenthetical language that the contracts have. The kind of the issue with those forms is that they are currently up for adoption at the August meeting. So they're a month ahead from these other forms. So if we make a substantive change, then we would have to repropose most likely. And because the change initially to those forms was a statutory change, I think we were anxious to get that out. That would delay that. So that's the only kind of twist with those forms.
Brian,
I
I
don't
would
recall, oh, wait.
go ahead, Charlie.
I don't recall seeing, just in anecdotal cases, a lot of people filling things out in the special provisions of the temporary residential lease. Now, maybe I'm not seeing that, but I just don't see them doing it much, so I don't know if it's as big an issue.
Yeah, I'm going to agree with Charlie. That's what I was going to say. I don't anticipate that we'll need to make a change to those lease because they're not abusing it there like they do in the initial contract. So it'll have to change in, all of the farm and ranch, new home. I mean, all of those, but not in the addenda.
I'll take joy in the changes we're going to make and not worry about this.
Amen.
Okay, any other comments or suggestions on anything else? Okay, so we've now come to the next agenda item, which is our next committee meeting, which is October 14th. So by then, we hope to have comments back from the industry and the public about the changes that will be proposed by the commission. Any other business anybody wants to bring up? Well, good work. I appreciate the quick response and the good meeting, and thanks for this work, and hope everybody has a blessed weekend.
Could we get an email with the final language that we just did?
Yeah, we can do that.
Super.
Thank you, Ron. Thank you, staff. Thank you,
Thanks,
everybody.
Thanks,
Thank
Elvis.
you.
Bye.
Bye-bye.
Thanks. Bye.